Okay, Shannon, you can put us on now. This is a matter of White versus White. Both parties are present as well as their attorneys. Ms. Joanne Louts for the plaintiff, Mr. Scott Norton for the defendant. I understand from communication with my secretary that you've reached an agreement.
Yes, that's true, Your Honor.
Correct, Your Honor.
You wish to put that on the record?
Yes.
Go ahead.
So the parties have agreed that Mr. White will begin to exercise unsupervised parenting time on alternate weekends and holidays, according to the friend of the court's temporary order for the next 60 days with the following condition. Mr. White is to complete a full psychological assessment performed by a qualified licensed psychologist that would include a full range of psychological tests. The assessment is to be completed within the next 30 days. The results of all the testing will be provided to the court under seal and to counsel for the parties. Counsel and parties will agree to keep those records confidential. Mr. White is to follow any recommendations made following that evaluation. Mrs. White will continue with her counseling and will comply with any recommendations or referrals. Her records will also be made available to defendant and his counsel, and those records will also remain confidential. The two oldest boys, Zane and Kyle, will continue in their counseling. Mr. White will be allowed to access the counseling records and make contact with the counselor to make determinations as to the progress of the counseling. Mr. White will not use marijuana or any spiritual medicinal substances of any kind while the children are in his care. Mr. White will be required to have all the children in proper car seats, boosters, or seat belts whenever the children are riding in the car with him. If the children wish to contact their mother at any time during their visits with dad, they will be allowed to do so. Both parties will agree to participate in complete parenting classes and will provide evidence of their completion of those classes to the court and counsel. Mr. White is not to leave the children in the care of anyone that's not known to Mrs. White. If Mr. White needs a babysitter for any period of time exceeding 4 hours, Mrs. White will have the right of first refusal. And the parties will revisit the issue of parenting time prior to the trial date that's currently scheduled in July of this year. As far as the financials, also Mr. White will become current with his child support and daycare costs with his share of the tax refund. Concerning the stimulus payments and the taxes, the parties have agreed to the following. Each party will keep the stimulus funds that they have and will not seek further reimbursement from the other. Any further stimulus payments will be distributed according to how the payments were paid by the IRS. For example, if the payment is per household member, each party would receive the amount for their respective household members. Adults would receive their amounts, and the amounts for the children would be paid to Mrs. White as the primary physical custodian. Mrs. White agrees to cooperate in filing a joint 2020 tax returns with her husband, with the understanding that all of the federal, state, and local refunds will be equally divided between the parties. Mrs. White is to receive copies of all the tax returns filed and shall receive her share of the refunds within 7 days of receipt. And again, Mr. White's going to pay any child support arrearages or arrearages on daycare from his share of the refund. Any additional child tax credits that may be issued by the federal government in 2021 will be equally divided between the parties. And I think that covers it.
Mr. Norton, can you confirm?
I confirm, and I'd also like to thank Ms. Locks for cooperation. And when I reached out to her to try and resolve this matter short of an evidentiary hearing and in parties as well. And I'm confident that we'll be able to come up with a consent judgment of divorce before the trial date.
very well. I do commend the attorneys, I think, and the parents for that matter. I think it's always better when you can reach an agreement. The agreement that was placed on the record is unlikely one I would have ordered specifically, just because it has so many
Bells and
unusual-
whistles.
Yeah, I mean, it's always better if you can work these kind of things out, because then you can deal with those kinds of bells and whistles that typically I don't have the insight that parents have. So, Ms. Laux, do you wish to question your client as to the terms of the settlement?
Yes, Your Honor.
Go ahead.
Would you swear her in, please?
She doesn't need to be under oath to state her agreement.
Okay. Ms. White, you've heard the settlement that's been placed on the record. Do you understand its terms?
Yes.
Are you in agreement with the terms?
Yes.
And do you believe that you had an adequate opportunity to consult with counsel concerning the agreement?
Yes.
And is it your intention to be bound by the terms of that agreement?
Yes.
Thank you.
Mr. Norton?
Yes, Mr. White, you heard the same questions. You understand what was placed on the record?
Yes, sir.
Are you in agreement with what's placed on the record?
Yes.
Do you have any questions or comments or concerns for me or the court?
No, I don't believe so. No, I do not.
And do you agree to be bound by the terms?
Yes.
Very good. I'll look forward to receipt of this consent temporary custody order. And hopefully it leads to a full resolution. But if not, you still got a trial date, and you'll certainly have the opportunity to address anything that the parties cannot agree on. Mr. Norton?
Point of order, Judge. I understand you met with the two oldest boys yesterday.
I did. Very nice young men.
Great to hear. That's surprising. In the event we go to trial, would I be able to inquire as to the court's notes or interpretations of those interviews?
No, they're required to be completely confidential. I cannot disclose what these boys told me, not only because I'm prohibited by rule. I promised them both that I would not tell anybody what they told me, and I intend to stand by that promise.
Understood, Judge. I just wanted, again, I fully confident that Ms. Laux and I will come up with a consent judgment of divorce well before the trial date. I was just, as a point of order, I wanted to know if, should we go to trial, how that would play. Yeah,
since I've already interviewed them, the others are too young. Everyone's agreed. They were both able to state a preference and a reasonable basis for the preference. I will keep my note of that interview, but I suspect I'll remember. Again, they're very nice boys. The parents have done a good job raising them.
Thank you.
Good to hear.
All right, thank you. Have a good day, everyone.
Thank you, Your Honor.